Hi, Jennifer Witt here with the Witt Law Group, talking today about prosecutors and what are they like, or what do they think about you or your case, or how do they look at cases. And it's going to be kind of a broad brush because obviously the more serious felony cases, different personality types, different experience level. The purpose of analyzing the case is different. Going to trial, the punishment model is more present at the felony level. For misdemeanors, you have your newer prosecutors. They tend to be very little experience or no experience. It's their first job out of law school, but their training is geared differently, and they tend to have a lot of cases. So, again, some generalities I can share with you. Number one, most of you, if it's just a basic misdemeanor, you're probably not on their radar. They don't, there's nothing special about your case that they're going to dwell on or think about or stand out. They have a lot of cases. I mean, they just do. In most cities and counties in the state of Washington, it's very different than the federal level where they have far fewer cases. State attorneys, county and city municipalities, they have a lot of cases. So you're kind of lost in the shuffle. That's good and bad. For some people, that really bothers them because it's turning their life upside down. It's the first time they've ever been in trouble, and they want to share so many things about their lives and what a great person they are, and this is one off. And if you could just tell them who I really am, it's just not going to happen. And when you do get a prosecutor's ear, it's for 1 minute, 2 minutes, tops 5 minutes to discuss a case. So you choose that time wisely, and you choose the information you want to share very carefully, strategically, and what is most likely to help your client. So the fact that everyone loves you in the neighborhood you're not going to spend 2 minutes of your 5 talking about things that aren't relevant to help your client. So, first and foremost, you're probably not that relevant to them. You're not standing out, and that can be a good thing. People who, during your arrest or during the investigation, but typically during the arrest, were really full of themselves, like, I know my rights. This seems to be a big thing the last 5 years. I don't know if it's free law school online or whatever, but everyone seems to know their rights, and yet they don't know how they actually apply, so they are running their mouths like crazy. They look offensive. They're threatening. Do you know who I am? Do you know I'm getting out of this? You're never going to work again. You're going to be fired. You're going to jail. I'm suing you. I mean, the list goes on and on. That does get a prosecutor's attention, mostly because you are wasting so much time, and sometimes you are putting the officer in danger. Sometimes these, my constitutional right debates, are happening on the side of a road at 1 a.m. Nobody appreciates that in the prosecutor's office, and they're going to make sure you learn to debate in an academic setting and not with law enforcement. So that may not sit well with you to hear that, but that is true. If you did that, don't be surprised if your case is much harder to resolve, because it's just, they're going to make sure you get the impression that debates happen in a courtroom, not on the side of a road. If you have constitutional rights and legal remedies that you want to bring forth, you do that in the court of law, not with a deputy on the side of a road. You just don't do it. And you may be right, but trust me, you will be losing that argument. And if you had a case that was great for negotiation and you spent, half an hour making life hell for a deputy, prosecutor is going to return the favor to you. So be aware of that. Third, this is more for, I'd say, our female clients. This is kind of a strange phenomenon that sometimes happens, but sometimes people feel quite charming when they are drinking or using other substances, and they think they will get out of the arrest by flirting and being cute. And cute physically and intellectually. They think they're, you know, really pulling one over on the deputy. It's especially cringy when it's on tape and it's, you know, on a dash cam, or it's on lapel cam when you're at the station. That is really not good. Sometimes it can be kind of, it gets the prosecutor's attention and they get a chuckle out of it, and that's kind of it. Sometimes the client will go too far and they are so cutesy that they're pretending they don't know how to blow in the breathalyzer, and oh my gosh, and you know, a lot of batting of the eyelashes, and it does not sit well. No one likes it. You know, across the board, the prosecutors don't like it. It's a waste of community resources, and officers sitting there at 1 a.m. trying to get you to do something. You either refuse the breathalyzer or take the breathalyzer, but they are not impressed with you batting your eyelashes. And that's kind of a mixed bag. If you were just kind of dramatic and you carried that on too long, yeah, again, that goes back to kind of I know my rights. You may get a little more, you know, maybe a little more challenging to resolve your case in the way the defense attorney wants to. Sometimes, again, it's just a chuckle if it was like, oh my gosh, that was a spectacle. But be aware, if you think you did that, your defense attorney is probably earning their legal fee because it'll get talked about. And then the lastly is more to do with victims in domestic violence crimes, where in the state of Washington, if you've watched any of our other videos, you understand domestic violence isn't the crime, it's the special tag because of the relationship. And oftentimes, because of our mandatory arrest laws, people get arrested where there was no crime and there was really no assault and nobody's a victim. But because officers get called and something, again, no touching is required, fear is just fear or apprehension. So you get a lot of people swept up in this, and rightfully so. Victims are mad because often the victims are mothers and they have 3 and 4 kids at home, and now dad has a no contact order for the next 3 to 4 or 5 months, and everything falls on mom's shoulders. So mom now has to go to work, plus do every sporting, how the dividing and conquering doesn't happen anymore. It's all on her. So after a week of that, mom is getting very angry, and she starts calling the prosecutor about the lack of justice, and I'm not a victim and I want to drop these charges. And in the state of Washington, victims don't drop charges, they don't bring charges, and they don't drop them. So this escalates, and the quote victim is so mad and often keeps calling. Now, I 100% believe a victim should call a prosecutor when you feel this is unjust. You are not a victim. You don't need their help. If these events didn't happen as they're portraying them, you should express that. Calling 10 times a day and yelling and being dramatic, not the best route, right? Because the more you lean into the drama, the more chaos that you seem to surround yourself with or bring to the table, the more likely that the prosecutor thinks that you are one of the victims that they learn about in their training who actually doesn't know that you need protection. You are part of the domestic violence cycle, is that the prosecutors are taught that you recant. That's part of the domestic violence, cycle. And for your own safety, you're just recanting those statements. But in fact, you do need their help. Well, some small percentage of women do need that. They do need a prosecutor to step in because they don't have the courage or it's not safe enough for them to do so. However, because of our laws, I do think there are a large number of quote victims who are not victims, and they are very, very frustrated with the Washington this process of mandatory arrest. But again, be cautious in how you handle that. If you have an attorney you can consult with, do so. It gets dicey when you're trying to have your husband's attorney weigh in, because that can, lead to, appear to be like, witness tampering. So, sometimes depending on the nature of the relationship, we just refer someone over to another defense attorney. Call this person we know and ask them how you should, talk about the case with the prosecutor. So it will kind of depend on the facts of the case, whether this really was, a mistake. But you really want to be careful to present your side of things in a respectful, thoughtful, coherent, non-dramatic way, because that is another way in which a DPA or a deputy prosecutor will kind of have your loved one back on their radar, front and center on their desk. And that's honestly not good. DPAs have hundreds of cases. They're super busy. You kind of just want to, again, not be drawing attention to yourself other than certain things that your attorney knows will be relevant in negotiation. And you just kind of want to manage that. As the case comes up and they're ready to talk, then, trust an experienced defense attorney. Don't weigh in on things that aren't relevant. Don't bother the prosecutor. Again, if you were one of those folks who was threatening everyone at the scene and swearing at everyone, or you were being cutesy and flirting with everyone, an experienced defense attorney is going to know how to handle that, and has probably had plenty of those conversations with the prosecutor. So they're going to, be able to delicately dance around this, one-off day for you. So hopefully that helps you understand. It feels uncomfortable for most people that a prosecutor isn't spending as much time as they think they should. Defense will always say, "Oh, that's a good thing. If they're spending a lot of time thinking about you, that's not good," because it's particularly where a prosecutor might have 300 cases. If they're spending a lot of time on yours, it's usually not for a good reason, not in your best interest. So trust defense attorneys. And again, this is a caveat because it's a broad brush. It's going to be a very different response if we're talking about felonies, and it may be very different depending on a county. Some prosecutors' offices in the state kind of have a reputation. So, if you have a case in a certain county where, it's basically plead or go to trial and there's no negotiation and it's really kind of nuts, you're gonna have to ask a defense attorney in that county, and of course you always should. In my opinion, you always ask local, wherever you are charged with a crime. Talk to the defense attorney in that county or city. You just will get way better advice, very specific to what you are facing. So I hope this helps you. I know, again, it's pretty broad and general, but I do want to alert some of you who may have been, doing your, debate club on the side of the road. It's probably going to hurt you a little bit. So, just be prepared for that, and know, your defense attorney is used to it. We've had cases like that, and you get through it. But you probably are on someone's radar. So anyway, hopefully if you appreciate this content, please hit like and subscribe, and thank you for watching.